You're live.
Okay. All right. Good morning, everybody. It's Friday, April 14th, and we are looking still at our rules of procedure for the Sexual Harassment Prevention Panel for the House. And we made there's some new proposed language that we're going to consider today. So, Damien?
Okay, great.
Take it away.
All right. So I think everybody's got a copy of the draft in front of them.
Yes. Thank you, Lindsay.
For that
Yes, thank you, Lindsay.
and for highlighting the changes. That's really great.
Yeah, so most of the new language is highlighted in yellow. I see some language on the first page which is underlined but not highlighted in yellow. So I wasn't perfect highlighting everything, but if you look down at the definition of panel staff under definitions, number 4, we're just adding after legislative operations, legislative human resources, and legislative counsel, we're adding as well as outside legal counsel or investigators retained by the panel.
We're going to have access to outside legal counsel. Okay.
Yep.
I think that's okay, right?
Yep.
Everybody,
Yeah.
we just sign off on that? Yeah.
Yep.
Okay. Under Rule 2, instead of calling it informally contacting the panel, we would call it just contacting the panel. And this is to start getting away from the concept of the informal resolution and the effort to look at it as an alternative resolution. And also to keep in mind that people may contact the panel. And I added a question right under the heading there is, do you want to add language regarding general inquiries? So a member who comes to you and says, so I saw this in committee the other day. Is that sexual harassment? Is it discrimination? Or is it just someone being rude? And it's just sort of a general question. Or, does the policy apply to X? And so I don't know if you need that language in there or if you want to have that language in there. It's just a question for you.
So if that happened to me, I would refer them to you, which, because I wouldn't dare answer that. I would tell them to go to you.
And that's fair. So, but yeah, I think there are likely to be questions that you might feel comfortable answering, and other questions that you would say, oh, I don't know where the line is. Let's talk to Damien, or let's talk to Arlene.
Okay.
Yeah, I think it just might be worth thinking about whether you want to mention that here. I think it's already mentioned in your policy that people can contact you informally with questions. But I think we've had ongoing discussions about the implications of that because of if you become aware of actual sexual harassment that's ongoing, then the panel needs to do something and so forth. But it's just just something to think about whether you want to add anything on that. You don't have to. It hasn't been in the rules for a while at this point, if ever.
I think that if these are our rules of procedure, we want to lay out. Okay.
Does A1 take care of that?
Yeah, you could just say any person may discuss. I might say
Where?
Yeah, may discuss an incident or conduct or inquire about the policy.
Yeah.
Yeah.
Okay.
Okay. Can we agree on that?
Yeah.
That references your situation like, I don't know about this. What is this? Okay.
Yeah, because I know I have gotten hypotheticals over the years where I always wonder, is there something behind this? But, the person's just saying,
I'm asking for a
hypothetically.
friend.
Exactly, and you never quite know, but you also want to give them the advice of like,
Yeah.
well, if that happened,
And to let people know who are reading this, that that's what they can do.
yeah,
Because a lot of people are just like, I'm not sure I want to get into this. I don't want to rock the boat. I don't want to get involved in something that's, okay, great.
and then at the bottom of A2 there, or at the end of A2, I just switched out staff to the panel for panel staff. Fewer words.
Yeah.
And then in B1, I added or potential complainant to reflect that people may not have filed a complaint. They may just be considering their options. And then you'll see for beginning in B1 there towards the end, you'll see everywhere informal resolution is. I've struck informal and put alternative or mediated in brackets while we try to think of a term for that.
Okay.
Going on to page 2.
Do you think we should discuss that now or?
You can. It's also in Rule 3, so we could discuss it when we get to Rule 3 too.
What do people think about that language?
I mean, do we even have to qualify it? Can we just say including any resolution under Rule 3? I mean, do we have to say it's mediated or alternate? Can we just say?
Yeah, you could just say, would like to pursue a resolution under Rule 3.
Right.
Different, it has different options. So
Yep.
that sort of covers,
And Rule
could be
3
mediated.
may, yeah.
Okay.
Everybody agree on that?
Yes.
All right. Okay, on page 2, I struck informally at the start of subsection C. Again, just to reflect that, it's just contact. I'll make the changes to the informal complaint or the resolution language throughout. One thing I did want to note, though, is that subsection D says that for each alternative mediated resolution, the panel shall consult with legislative human resources and either legislative counsel or outside counsel as appropriate. But that's repeated in Rule 3B, where it says the panel shall gather information and shall consult with legislative human resources and either legislative counsel or outside counsel. So I would suggest striking subsection 2D there. It's just redundant language.
Okay.
Okay. All right. For Rule 3,
My pen is not working here.
so this is being changed from informal complaint resolution. So I had alternative or mediated resolution process. One thing that just hit me as you all were discussing getting rid of the alternative mediated resolution language throughout is I think one of you said because it lists options, you could just say alternative resolution options. And that might be
Right.
more reflective.
And that covers mediated.
Yep, because mediation, facilitated dialogue, and discussion of the incident or conduct with the respondent are the three options in there right now. And that was just what I could think of. If there are other things you can think of.
So everywhere that it says alternative mediated, we would say,
Just be alternative resolution. And then C provides that the different options. It's kind of,
So I guess
it's okay, I got one.
this is the resolution process if you don't want to file a formal complaint.
Exactly.
Okay, so I still don't get why we have to say alternative, because in C1, we say these are the different things that you can resolve the, you know.
I think it's that, and I think I can phrase this better, but I think it's that this is an alternative to filing a formal complaint.
Okay,
Yeah.
somehow.
So I think I
Yeah,
would
'cause-
start,
Because this is the only resolution process we're going to have short of filing a
Yeah.
formal complaint. So I don't really particularly like alternative resolution.
We could
Because this
just
is the
say-
only resolution you have besides filing a formal complaint. So I don't know if I
yeah, we could change the title to
don't know.
something like,
Good point.
I'm just trying to think of something that's not going to be 2.5 lines long.
Right.
We could change it to something like,
You still don't like resolution process? I mean,
well, so my concern about, you could call it resolution process, and then like semicolon, no formal complaint or something like that,
so
or without formal complaint.
Right, I mean, I guess if you just say resolution process, and then like you were talking about maybe putting language in Rule 2 somehow for contacting the panel, maybe you put some statement under resolution process.
Yeah, I would,
If you're not going to go through the formal complaint process, you know, something like that. Kind of explain what the resolution process is for this one. In lieu of a formal complaint, these are the, I don't know,
yeah, I would, yeah, almost say under A, we can start with in lieu of filing a formal complaint.
yeah, I like the idea of specifying that it's different.
It's different.
From a formal
Yeah.
complaint. And I think
yeah,
it's
I just
helpful
don't,
for people
I guess I don't like.
who are reading this to know that, oh, okay,
Yeah.
I have this option.
Right.
Yeah, okay.
Okay.
Because we do state what their options are. Mediation, facilitated dialogue, or discussion of the incident. So, you know, we have that in the resolution process. So, I don't know.
Okay. Okay. So then we could, in C1, we could say 2 or more panel members may attempt any of the following resolutions in consultation with the complainant and with the consent of the regulated individual. And then right now I have mediation, facilitated dialogue, which I see as being something like, it could be anything like a restorative circle where all impacted parties are present and discuss how it affected them, or it could be other forms of dialogue where the panel members are acting to just sort of facilitate the conversation about what happened. And then the third option, C, is what we've traditionally called the informal resolution process, which is where 2 panel members talk to the individual who engaged in the alleged conduct. If you think of other things that should be on that list, please let me know. But I can't think of anything. I was kind of hoping that Representative Hedrick would be here since I feel like his professional experience might also bring up other options, but we can
say, or any other options, you know,
yeah, I mean,
have this?
appropriate.
he does. He does. I think everybody in the panel has it.
Yeah.
And I think mediation and facilitated dialogue are really broad categories. I mean, mediation can be the parties sitting at the table. It can be shuttle mediation
That's what I
where,
was going to say, in 2 separate rooms.
yep, 2 separate rooms or even, you know, meetings over a series of days.
Right.
Well,
So I've, you know, when I was in private practice, I did versions of all of those.
Yeah.
So I think those are all options. And then discussion with the respondent, I think it does give you 3 sort of broad options.
I can ask Troy, he sits right behind me. I'll probably see him at the floor. You can just ask him if he has any other suggestions.
And we can always finalize it next week too with
Yeah, okay.
those options, because I'm going to have to draft more changes.
Yeah,
here, so.
okay.
Okay.
There's something in cabaret about that last night.
No.
We were done and now there's 4 more changes requested.
Yeah. So moving down to C2, instead of repeating the confidentiality requirements, I just said the record shall be kept confidential pursuant to the provisions of Rule 20, which also now has language in it allowing the complainant to provide a limited waiver for certain purposes. So for example, if their complaint encompasses both sexual harassment and discrimination based on their race or their religion or something like that, then they might say, I'm authorizing the panels to talk to each other about what they're doing. And then if the complainant is not present for the resolution, the panel members shall notify the complainant of the outcome. So just really straightforward, especially with that discussion with the regulated individual option. You know, it's just a report back on, well, we had the discussion and ideally they acknowledge that, you know, they did something wrong and they're sorry and they won't do it again.
Right.
So, following, let's see, I think I would just say on D at the top of page 3, I would say following a resolution under this, this rule, the chair of the panel shall promptly inform the speaker that there was a resolution. and going on from there. But just that'll shorten that up a little bit. Preventative action. I think I would say, instead of saying pursue an alternative or formal resolution, I would say pursue a resolution or formal complaint.
Yeah.
And I will go through the rules again to make sure I don't have to make any other changes. We're about to skip a lot, but before we do that, at the bottom of page 3, Rule 5, we are adding, so at any time during which the individual was, so a person can submit a complaint about a regulated individual at any time during which the individual was a regulated individual, or for members of the House of Representatives, conduct that occurred during official General Assembly events between the date on which the member was elected and the date on which the member was formally sworn in.
Right, that's what we discussed last week about
Yeah.
that period.
Stuff.
Yeah, it covers orientation and the JFO briefing.
Yep.
It does not cover things like celebrations with your county political party following the election. So, top of page 4, just adding a subsection here that says a complainant may elect to pursue, and then I would say a resolution under Rule 3. In lieu of proceeding with the formal complaint at any time, if the complainant elects to pursue resolution under Rule 3, the complainant's formal complaint shall be stayed pending the outcome of the resolution, and the complainant may elect to proceed with the formal complaint if the resolution is unsuccessful.
That's clear.
Yep. All right, and then we get to skip all the way to page 7. We might make the 9 o'clock cutoff.
Yeah.
So this is something, I think, given the time, we won't have time to decide this today, but there was a discussion about should the burden of proof be preponderance of the evidence instead of clear and convincing evidence. So the highlighted language at the top of page 7 would change the burden of proof to preponderance of the evidence, and then it describes what that standard, so versus clear and convincing, which means it's highly probable or reasonably certain based on unambiguous and plain evidence that is reasonable and persuasive enough to cause the panel to believe it. Preponderance of the evidence means that on the whole of the evidence before the panel, it's more likely than not that the alleged violation occurred. So basically, preponderance means that if you think of the scales of justice, you've gotten to the point where the evidence tips the scales in the favor of one side or the other. That's all you need. Clear and convincing means that it not only has to tip the scales, but it has to be unambiguous, plain, certain evidence in front of the panel that's reasonable and persuasive enough to cause the members to believe that the conduct occurred. So it's not quite beyond a reasonable doubt. So you could still have some doubts, but it has to be on the evidence on a whole, it's convincing. It's clear and convincing to you that the conduct occurred. So it is a higher standard. The civil court standard for proving discrimination is preponderance of the evidence. So we have a higher standard internally. Historically, some of the discussions about that have related to the fact that the panel members are not professional
Right.
attorneys or judges. And so just concerns about, the close calls on preponderance of the evidence versus clear and convincing. But it really is a policy question for you. We've had clear and convincing as long as I've been here, but there's nothing that prevents you from changing that.
What did the Senate do?
They have kept clear and convincing.
Yep.
So,
And that's a factor I think we need to look at.
Yeah.
yep. And the discrimination panel also, I believe, has a clear and convincing
Yeah,
standard.
I'd rather stick with, I think it's better
I,
Senate and discrimination panel. I think we should stay the same.
I think so too.
Okay.
All right. Okay, outcome of the hearing. So these are just highlights for discussion here. The possibility of having a no finding scenario. So you have a hearing, you have 5 members present, and the vote is 3-2. What happens then? So you don't have a clear, at that point, if you don't get 4 votes, I think, because right now, the way it's worded is you need 4 votes to dismiss the complaint, or you need 4 votes to find that the violation occurred. But there is the possibility that the panel, instead of splitting 4-1, splits 3-2, and then there's no outcome. And I don't know that I don't think we've ever really contemplated that before, but it is a definite possibility under the rules. The other issue is what happens if you have a hearing where one member's had to recuse themselves or is unable to participate. Are you going to require that all 4 members vote one way or the other, which really raises the possibility of a no finding?
Right.
Or are you going to have an alternative? So I think just food for thought, since it's 9:00 right now.
Yeah. Okay.
In Rule 18 on page 8, just to highlight that we need to discuss whether the speaker should or should not be listed as potentially making the public statement about publicly noticeable corrective actions. So there was some discussion about that.
Yeah, and I think I brought that up. I would say a may instead of shall.
Okay,
Depending on the situation,
yeah.
person, et cetera.
Yeah, I mean,
But I would think
you
it's
could
our
also
job.
say the panel chair in coordination with the speaker as appropriate.
Yeah.
Shall announce the actions, because then, the speaker may say, well, we just stripped committee chair of their chairmanship. I'd like to speak.
Yeah.
Yeah.
But it could also just be that, the speaker doesn't want to be involved at all.
Okay.
Yeah.
And I think my point was that it helps her stay nonpartisan, even though I think it is, but it could be perceived as a partisan action.
Right. So, okay.
Okay. All right. So can we meet next week? Yeah, that gets to be April 21st.
Right. And then we still have language on page 9 to go through next
Yeah.
week, but we'll just do that then.
And what about, we also need to look at the Senate policy and make sure that we're all, do we need to do that? Or is there just little tweaks that need to be done?
Yes, so I will, when we finish this, I will bring that to you. The tweaks are relatively minor.
Okay,
I think we could go through them quickly. I can send that out
Yeah,
to you.
that'd be great.
yeah,
Just marking up
The difference.
send you their policy and then send you your policy with the differences
Okay.
highlighted.
So,
That'd be great.
so if everybody can look at that before next week.
Yeah.
Maybe we can wind up next week.
Okay,
What do you
great.
think?
That would be historic.
Well, you know, I was trying to, I want to look on the thing, what day was their policy adopted last year? It was-
Thank you.
It was the end of April.
April 29th.
April 29th. Maybe we can beat that date.
Yeah.
All right.